So good afternoon, Mr. Ian Wilkinson, KC. Good afternoon to the President of the Bar Council. Good afternoon to the Vice President of the Bar Council. Good afternoon to members of the Bar Council, and good afternoon to all members of the Bar attending. On behalf of the Chairperson of the Judicial Education Institute, the Chief Justice, Ms. Mabel Ajaman, I'd like to welcome you all to this afternoon's presentation on probate practice and procedure. Our session this afternoon will be facilitated by none other than Mr. Ian Wilkinson, King's Counsel. His bio has been shared with you and it will be shared in the chat as well. So without further ado, I hand you over to Mr. Wilkinson, King's Counsel.
All right. Good afternoon, everyone. I think that we are on the same time. I'm in Jamaica right now. It's just after 3 o'clock. So from the start time, I think we're on the same time. Pleasure to see you here. It was a little touch and go for me to make it because we're under a tropical storm watch and we have had a lot of rain and flooding. In fact, news just coming in that some persons have been marooned in some areas. School has been out, no school today, and offices have closed early. And the internet is a little spotty. I give you that background just to say that if I get disconnected, it's not my fault. Call it force majeure. But it's good to see you. So let's make hay while, well, I can't even say the sunshine because there's no sun outside, but let's get moving and we cover as much as possible. So a disclaimer, I do not call myself a probate expert. I just want to make that clear. People call me that. Under Jamaican law, I'm not allowed to call myself an expert because the General Legal Council, of which I'm a part, which is a regulatory body dealing with lawyers or governing lawyers, does not have a system in place as yet. We hope to have it in place by the first quarter of next year, where people are actually certified as experts or certain practitioners with expertise in constitutional law, criminal law, conveyancing, and you name it. So although I have a wealth of experience at probate practice, in fact, I taught at the Norman Manley Law School final year lawyers who do probate. I taught there for approximately 30 years. That is 30 years. I know, don't be fooled by my youthful appearance. I taught there for 30 years. So it's been a long ride, even though by large, I'm an advocate and I practice largely in court, hence the KC, but probate practice and procedure is very dear to my heart. In fact, when I studied law as a student, the practical aspect of the law school, it was then called the law of succession. But combined with my Trinidad counterpart, some of you might have heard of her. She has had a colorful life in other respects, Mrs. Karen Teixeira. We knocked heads. I actually consulted with her on her book, which deals with probate practice non-contentious in the English-speaking Caribbean. And together, we managed to get the members of the Council of Legal Education, which govern the law schools in the region, Jamaica, Trinidad, Wooding, Bahamas, Eugene, the Puget, and other places, including the Faculty of Law in Barbados and so on. We got them to change the name of this. So that is why I prefer to approach it as probate practice and procedure, stricto sensu. So this afternoon, we don't have a lot of time. This is perhaps the first of a number of different lectures or presentations, depending on how you want to call it, or seminars. But we are going to be, I'm going to be looking very, very briefly at your systems in the Turks. I'm not going to spend a lot of time on that. Chances are you understand the systems much better than I do. I actually started to look very closely at what happens in the Turks and Caicos Islands last year, when the previous registrar sought my assistance with a few things, and that is Miss McLean. And I had occasion to look at a number of statutes over there and to discuss your procedures and to look at certain documents. In fact, I looked at your probate and administration ordinance. I had to look at your probate resealing ordinance. I looked at non-contentious rules which you use, borrowing in a number of instances from the United Kingdom. And I looked at quite a few things. I looked at your non-contentious probate rules and so on and so forth. and I have a fair idea of what happens. I've looked at a number of precedents, documents used by various practitioners over the years. I've also had occasion, as recently as today, to speak to persons who practice a fair amount of probate and practice and procedure work. So I have had my baptism and my tutoring, and I have a fair idea of what happens there. So I'm just going to so in terms of what do we aim to accomplish this afternoon? Well, one, I'll touch on probably say 3 or 4 of the major applications held or pursued in the Turks and Caicos Islands. 2, by comparison, I will look chiefly at Jamaica, where I am based right now. I have actually had the privilege, I should say, of looking at the laws for more than 20 odd different countries around the region. In fact, I've visited with registrars in a number of the registries. I can speak to as far away as Dominica, Belize, Trinidad and Tobago, Barbados, just to name a few of the places. So I have a general idea of what obtains in other territories. So I've served as a consultant with the Jamaican government, and this what I'm just saying now provided the basis for a total revolution in probate practice in Jamaica. And I'm hoping to see some of those changes enacted in the Turks and Caicos Islands, but we'll come to those presently. So we will look at the TCI briefly. Then by comparison, we will look at Jamaica, using it as a base. And now and then I might, go over to the United Kingdom, but I'm dealing largely with the region. And then I will make some recommendations for improvement. So those are the 3 main things which I have set as the objective for this afternoon's presentation. So let us start in earnest after all of that. And at the end, I'll try and wrap up probably about 3:45 or so, and because we're scheduled to end at 4, and we can have probably 15 minutes or so of a Q&A if you have any things you would want to raise. What I would ask you kindly to do is, if you have any questions, not to interrupt me in between, in the interest of the flow and time, but just make a note of them, please, because I'm very interested in your feedback and any questions you might have, and then we can take them at the end. So if anything comes to you, just make a little note of it, because I'm certain it will be of some use to me as well. So let's get cracking. So I'm not going to insult your intelligence, but I'm going to say some things which might seem trite to you, and which you might think tacit, which will go without saying because you're practitioners. But based on my experience with some other lawyers and some students, I don't assume anything. So we're looking at firstly at probate, all right, which I'm going to treat with. And a little secret, I'm actually in the process of writing a book. I've written a couple of books, but those are chess books. I'm actually in the process of writing a couple of law books. So you are getting a sneak peek into some of the material from my next book, which is a probate practice and procedure book. I'm trying to write something akin to a Tristram and Coote equivalent for the region. So unlike I referred to Mrs. Karen Teixeira earlier, unlike Mrs. Teixeira's book, this book will cover contentious probate as well, and it will also have a wealth of precedents where, for example, newcomers to probate who might be setting up their own practices or will not have a lot of senior guidance will be able to get some assistance from the precedents in the book. So that project I hope to complete next year. It's been long overdue. So this is where we go in earnest. So probate practice. So probate practice is, of course, the practice of law which treats largely with estate matters, dealing with situations where someone has left a will, where we say that person dies testate, someone has not left a will, where that person dies intestate, or where somebody has left a will, but that will has not disposed of all the deceased property, where you have a partial testacy or partial intestacy, depending on your perspective. And we also deal with a situation where someone has left a will, but no executors to administer the estate. And as part of this presentation, I'm going to touch very briefly on this whole aspect of resealing, which is usually a Commonwealth concept, but has been extended to North American jurisdictions. So the first one up, so to speak, is the issue of probate. Now, a grant of probate essentially is, as you bright people are aware, it's a court order, which literally puts the person to whom the grant is issued in the shoes of the deceased individual. So that armed with this court order, you can now go into a bank and withdraw the proceeds of the bank account in that individual's name. It is a very powerful tool. It is akin to a power of attorney for the dead, so to speak, because quite often people can issue powers of attorney to individuals, and they can use those documents properly executed, signed, sealed, delivered, and all of that to transact the business of that individual. For example, if he or she were to leave the jurisdiction, but that person is alive, and generally speaking, that power of attorney often ceases on death. But with probate now, the effect of it is similar, except that there's no donor or no grantor. Individual is dead. In the Turks and Caicos Islands, and this is how I propose to do it, I will touch on the procedure for the Turks, and then I will, by comparison, go to Jamaica as my base country. So in the Turks, when I looked at your various ordinances, we are different. You have all a list of documents like petitions, you have your declarations, you have an inventory which treats with the assets of the estate, you have an affidavit, you do a bond, you have the will, you death certificate. In short, to get a probate in the Turks and Caicos Islands, you could file close of up to 10 different documents. That's my understanding, based on discussions with the past registrar, discussion with current practitioners at the bar, among other things. In addition, when you file with the registrar, depending on the nature of the matter, and this is for probate, you could have your application being advertised in your gazette. I've never had occasion to use the gazette in the Turks and Caicos Islands, so I'm not going to pretend to be an expert with your gazette, but I understand your gazette is published, I think at a maximum, probably 2 times a month or something like that. So your situation is such with probate that it could take a while, based on what I understand, if it is the case where, and I say if, because I gather it might not always be done, that is something we can discuss. If you have to, if your application is going to be advertised, then it could take a while, because I understand that either there might not be space in the gazette, or the gazette, there might be delays, which can sometimes run into months, so I'm told. Now, that is your situation. I gather too, from speaking to some persons, and I would like your feedback on this, that you do not mark the will. I don't know if the persons on the platform, if all of you are very experienced with the marking of a will, but I can tell you, in Jamaica, the marking of a will was an issue, and many practitioners had no idea what to do to mark a will properly. So that when I served as a consultant to the government back in the year 2000, I believe, exactly, just over 20 years ago, we in our new civil procedure rules, which replaced what we used to call the CPC, which was the Civil Procedure Code, I actually crafted the marking clause so people could see what the marking clause looked like. And the marking clause, for those of you who might not be aware of it, and I said, not insulting your intelligence, just making no assumptions. For the uninitiated, the marking clause is a clause which you place on the will. It's the only time someone other than the registrar of the court, when he or she is granting or certifying the probate, the testator or testatrix, the attesting witnesses. Those are the only three persons who normally would write on the will. The only other time you see the will being written on is when the marking clause is affixed to it. And it is a clause which links the will to the affidavit which might be filed, or if you have to do an affidavit of attesting witness, then it links the affidavit of attesting witness to the will as well. So it is the marking clause, is simply a clause that is written and put on the will, where the executor who's seeking a probate would say, this is the paper writing. And normally they refer to the will as a paper writing, not as the will, but as a paper writing until probate is granted, because you have a document which on its face is valid, but until the court issues a grant of probate, that is what gives it the real legitimacy, because you can have many wills, but they're not, or codicils, which are alterations to a will, but they're not really valid. So I gather from speaking to practitioners that you don't really do marking as a general rule. That is something I think should be addressed, because we have had instances of fraud or attempted fraud. And because the marking is not required, that is one level, which level of protection which is not there. But we can speak about that in due course. So you have your probate application. Now, to compare that with Jamaica, so as I said, you could file up to 10 different documents depending on the state of the estate to get your probate in the TCI. In Jamaica, after the changes were made between 2002, when we passed the new civil procedure rules, which took effect in January 2003, and then we had some amendments in 2006. And we have had some major amendments subsequently, 10 years later, 9 years to be precise, in 2015. And we have a raft of amendments coming again, because I'm serving as a consultant with some other persons for more changes which are to come. So one of the reasons I haven't finished the book yet, because they keep changing, and some of the material keeps getting dated. But I'm just going to get it out regardless. So the beautiful thing is, these changes, you only need to file, strictly speaking, 2 documents, just 2, outside of the original will, of course, and the death certificate. The will is a given. But in terms of the documents, attorneys at law have to prepare for their clients. You only need 2 documents, which is the grant of probate itself, which is ultimately going to be issued by the registrar. And in Jamaica, we use what is called an oath of executor or executrix, or if more than one, oath of executors, which basically sets out the history of the matter, that we are the executors appointed under such and such will, such and such a person died, leaving a will. We will administer the estate. We were sworn faithfully to give a true inventory and blah, 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 render a true accounting. That is the oath. So in terms of the documents lawyers have to prepare, you normally just do 2, an oath and the grant itself, which is going to be issued. Now, that is a practitioner's dream, because I remember when I came to the bar in the late 1980s, when we were doing probate, you had to do letters, you had to do all kind of fancy documents, declaration of counting, you had to do will bond. In some instances, you had to have a surety linked to the bond, which I gather you still have in the Turks and Caicos Islands. So we had to remember, we had to be doing these documents, justification of surety. You had to do an extra fancy document called a Kalamazoo copy, all of those things. In fact, once we counted, and we had to do 12 different documents to get a grant issued. That came down to 2. So just imagine, if for your client, you don't have to do 12, but 2, the time and the cost that saves, and the wear and tear on your brain and your bodies and your practices. It's not every instance that more work will necessarily bring more fees. Sometimes more work just brings headache and backache, but that's for another time. So those changes were radical, revolutionary, and fantastic. And there's something else I want to throw in here before I move to letters of administration with the will annexed. With probate, sometimes you have to do, normally we had to do what is called an affidavit of attesting witness. So at least one of the witnesses, because generally the wills provisions, ordinance, or the wills act, depending on your jurisdiction, require, the statute requires that you need, every will to be valid must have at least two attesting witnesses, two witnesses before whom the testator's signature was acknowledged simultaneously. If the testator signed in the absence of the witnesses, but you must acknowledge to say, listen, this is my signature, they must be present simultaneously. Or if the testator is signing in front of the two of them at the same time, that is fine also. But one of those two, after the person dies, needs to swear an affidavit of attesting witness. That is a document I gather is used in your jurisdiction also. In Jamaica, we no longer use that. If, in fact, we replace the affidavit of attesting witness with an affidavit called affidavit of due execution. Now, the beautiful thing about the changes we made back in 2002, which took effect in January of 2003, is that if the will has an attestation clause, and any lawyer who's preparing a will ought to ensure that the will has an attestation clause, because there's a well-known principle of law, and you might remember there's a 1964 case from the UK called Ray Webb, W-E-B-B, which looked at the principle omnia praesumuntur rite esse acta, which means that, you presume that everything that's to be done has been done. So when you have the attestation clause in the will, that the clause, it says signed by the testator, in the joint presence of the attesting witnesses, who thereafter subscribe the will in the presence of the testator. That is a short version of the attestation clause. Once your will has that clause, there is no need for an attestation, affidavit of attesting witness, or in Jamaica, as it's called, an affidavit of due execution. What that does, it immediately removes the burden of you having to prepare that additional document. And that is fantastic, because there are times, ladies and gentlemen, when you can't find any of the attesting witnesses. And thereafter, you have to get all other documents done. Sometimes the registrar will call upon you to do an affidavit of handwriting, so that you have to get somebody to say, yes, the signature on the will was the testator's, and so on and so forth. So having an attestation clause saves some of that problem. And it is one of the things I would recommend to you, which I'm doing now in advance of my recommendations at the end. So that is probate for now. I'm going to move to letters of administration with the will annexed. Now, letters of administration with the will annexed is a grant of representation. The chief difference with it and probate, obviously, is that an executor is not applying. So there might be no executor for a number of different reasons. One, the will never appointed one at all. Or two, one was appointed but predeceased the testator, and the testator never replaced that person via codicil or otherwise. Or you could have three, a situation where an executor is appointed, but the executor, as I've seen in my practice more than once, the executor is a minor, and the minor can't take a grant, and the minor's parents might have to take the grant. So even though the parents act through the minor executor, the grant is not called probate, it's called LA with the will annexed, or as the people say, LA cum testamento annexo. Or you could have an executor who's an adult person but decides to go to study somewhere, go to the Sorbonne in France or some fancy place, and decides to appoint someone as his or her agent or attorney, and does a power of attorney. Armed with that power of attorney, that person can apply to have that will administered. But the grant issued is not probate, because the only time you get a grant of probate, or should get a grant of probate, is if the executor himself or herself is applying directly for the grant. So those are the circumstances where an executor might be missing and you apply for LA with the will next. You do most of the same things. Your ordinances speak it out. You still have this petition, which is done. Up till earlier, someone sent me a precedent in relation to one of your declarations, and that is done, some solemnization and all of that fancy stuff. And you do your bond and all of that. One of the problems I gather in the Turks and Caicos Islands, especially with letters of administration, and we'll come to letters of administration simpliciter, where there's no will, you know. I pause. I'm going to ask you a question. If you know the expression, if you can finish it, where there is a will, you can write it in the chat at the bottom. I will leave it hanging. The well-known expression, where there is a will, ... you can finish it. I will tell you at the end if you're correct. So the problem of gazetting rears its head again, because if you have a difficulty getting your application gazetted very quickly, you might have a problem getting your grant very quickly. And ladies and gentlemen, as I always say to my students and to other practitioners and even to clients, it sounds strange, but for me, probate practice is one of the most important practices in area of any practice in law. You stop and think about it, probate practice. Probate practice transcends every single area of the law that you can conceivably imagine. Some might want to make that argument for other areas, but I'll give you an example. In fact, when I was studying law at the faculty in Cave Hill in Barbados, well over 30 odd years ago, one of our teachers told us, it was a morbid suggestion, but she said, listen, when you become lawyers, you must always take up probate practice. And we were saying, why? And she said, there will always be work. Lawyers want work. There will always be work because people must die. Of course, you know, as little youngsters, we don't like to think of death. People are just cringing, but it is important to realize that probate practice transcends every possible area of the law. Let's look at criminal law. For those of you who might do criminal law, if somebody's murdered, that victim or deceased person, you immediately have a probate or letters of administration case because you now have a dead body. So there is that link with the criminal law. You have family law, where somebody might die and leave a matrimonial home. Then you have issues of constructive trust sometimes, and sometimes you have issues of if the house was held in the name of a company, for argument's sakes, how do you deal with that? These are just some instances of how you can have probate practice. It deals with conveyancing. If the deceased person died, leaving real estate, a title in his or her name, you immediately have a conveyancing angle to it. If the person died, leaving shares in a company, particularly a very thriving company, you now have the issue of how do, and the will says, I give these shares, for example, I see a famous name on the window, Ewing, brings me back to the 1990s and Patrick Ewing and the New York Knicks. We used to cheer for Ewing because he was Jamaican and, you know, we were Jamaican. If Mr. Ewing is getting a windfall, at least on the face of it, of 2 million shares, which might be worth millions of dollars, he can't get those shares until the estate is administered. So the shares are in a company. You're looking at company law policies, probably commercial law precepts. Can't get them until the estate is administered. I could go on with a number of other examples, but I will just stop with those 4 or so. So it shows how probate straddles like the Colossus of Rhodes, all the fancy other areas of law. All right. So that is what you do. So you file your application, your petition, supported by your inventory, your bond, your affidavit in support, your declaration, all these fancy stuff. And you might have to do an affidavit of attesting witness and so on. The difference in Jamaica, and you can tell me at the end if this is true, because I didn't see anything treating with it, but I gather that in the these good islands of the Turks and Caicos, that you do not really have a public trustee. In Jamaica, our public trustee is called the Administrator General. In a number of other countries, that's what they actually call the public trustee. And that is a legal officer in whom the estates of deceased persons usually are reposed when there's no grant of administration, especially when somebody dies intestate, to which I'll come shortly. So in Jamaica, we have an administrator general who can deal with the estate up to a certain amount of money, even without taking a grant from the courts. And I will come later to speak to the instrument of administration which we created in Jamaica, which is a tool which I would recommend to the Turks and Caicos Islands, but as part of my recommendations, just before we go to the Q&A. So in Jamaica, again, the number of documents which are filed are much shorter, significantly smaller in number, in terms of you have to have the will marked because there's a will. You have your grant of administration with the will annexed. And you will, of course, have this staple, the will itself, which is marked, and the death certificate. All right. Unlike what I understand happens in the Turks and Caicos Islands, where upfront, as attached to your affidavit, sometimes you have to provide valuations, appraisals, or you might have to provide birth certificates in proof of consanguinity, or you might have to provide a marriage certificate. Those things are not required in Jamaica at all, unless there's an issue at the back end. But you don't need those documents to get your probate or LA with the will annexed. What happens is if there are minor children involved, and that's something I would make some recommendations to you going forward, not necessarily today, but if there are minor children involved, then if there is no executor at all, and we're dealing with LA with the will annex, then you would apply to the Administrator General and you have to complete a special form of particulars for the Administrator General, providing the details now and the supporting documents to show why. That is if, for example, you want to apply for the grant. Who are you? You have to prove nexus. So you would supply the birth certificate and you would provide details of the property, a copy of the title, a proof of the value, and so on. But this is long before you even apply to the court. And all of this is in aid of getting the Administrator General to allow you as a private individual to go and get the grant, which in Jamaica, the Administrator General or the public trustee would normally do as long as there are no minors involved. Once there are any children under the age of 18, the Administrator General has a state responsibility to deal with that. And that is a different layer of protection for estates, which I gather you don't really have right now in the Turks and Caicos Islands as we have it, and how it's structured particularly. So that is LA with the will annexed. A beautiful thing about LA with the will annexed, under Jamaica's rules, and also I gather you really don't have it to the extent that we have it. There is a proper order of resort to the grant or entitlement. So you have the table setting out who can apply for the grant and in what order. And pride of place, of course, goes to the surviving spouse, and so on and so forth. The last one, main grant, is letters of administration, period, or simpliciter. There's no will. It's just a clear intestacy. Again, you have to do your petition, your supporting affidavits, your bond, your inventory, all of these fancy documents. You file them with the registry. No, I gather that, of course, in this case, the application must be advertised, and you do it through your gazette. Now, unlike what happens in the Turks and Caicos Islands, once they're adults, you don't need to go through the Administrator General or the public trustee to get permission to apply to the court. The problem is, if you don't do that, and it turns out that important information was omitted, then you might have a problem at the back end. But once there are no minors, the Administrator General will normally allow you to just apply for the grant of letters of administration. Similar to the Turks and Caicos Islands, as in Jamaica, your application must be advertised. And this advertisement is what they call notice in rem, or notice to the world. So it's usually advertised twice, but that permission to advertise comes from the registry. So if you file all your papers and the registrar of the court, depending on your jurisdiction, says, these papers are fine, you may advertise. They want you to advertise for a couple of different reasons. One, you bring your application to the attention of all and sundry, because you might have a long lost child, the deceased person might have had children all over the place and nobody knew about it because he kept it close to his chest. I don't know if you remember The Long Kiss Goodnight, a nice action movie many years ago, starring Samuel L. Jackson, who seems to be in almost every movie, and Gina Davis, when Gina Davis was an assassin. I won't tell you much about it if you haven't watched it, but even though it's an old movie, but it's still a great movie. And in the end, you know, he was doing an interview on TV and he says, you know, I have to be frank and earnest with you. You know, when I'm in New York, I'm frank. And when I'm in Chicago, I am earnest. I mean, it might seem funny, but there are people I've known in my practice who live double and triple lives. And I hope I'm not stepping on the toes of anyone who might be on the platform. Mea culpa. I don't know your business. It's just coincidence. All right. Just a disclaimer. I don't know who's doing any such thing. But you might have somebody who has a home in Providenciales and has 2 children, and then might have a different home over there in Middle Caicos and has different children, and right up there by Moochin Harbor as a couple more. I don't know, but sometimes these things rear their heads, and so that is why the notice is important, because we have had cases where people surface after notice, and the grant, which was approved provisionally, cannot be issued anymore. So once that happens, you have a real problem, and the registrar will not give you that final probate or LA with a will. We have had probate about to be signed and somebody turns up with a more recent will, because remember the authorities, you know, Simpson and Fox, Ray Bond, Wayland's estate, all of those lines of cases, which tell you that the later will in time shall prevail. So if you have a will dated 2010 and somebody turns up with one dated 2020, then it's a 2020 will, which is going to take precedence. We see that all the time. So the notices are good. One of the big improvements in Jamaica, which I gather you do not have in the Turks and Caicos Islands, is that the law was changed because of the problems we were having with our gazette as well, and getting things gazetted in a timely fashion. The law was changed to allow you to advertise your application by a daily newspaper. So you don't have to, we didn't have to use a gazette anymore. And of course, the newspapers got a lot more business and made a lot more money because the newspapers came out daily, and you could just advertise in them. But there was a little trick, because some practitioner made a mistake of advertising a newspaper which was not daily. It came out like 6 days of the week, but it wasn't published, I think, on the Sunday. And there was actually a case about it, and it was held that the advertisements were not good because this was not daily, because it came out 6 out of 7 days. So that put people on their toes, and they made sure that they used the daily newspapers. That has been a very good development, because it cut out, because I hear about delays in the Turks as far as the gazette's concerned sometimes. Believe me, in Jamaica, it's probably 6 times as bad. You know, it's very bad because sometimes the gazette doesn't come out for a while. So those are some of the improvements I'd make. So that is the issue with letters of administration. The last thing I'll touch on before I look at the recommendations for improvement, and I have been giving you some recommendations for improvement as we go along, but there are some more I will look at more particularly. The last thing I look at is resealing. Now, resealing, you have a probate resealing ordinance. I looked at it earlier as well. And I looked at it last year when I was having discussions with the previous registrar. The resealing, of course, as you know, is a Commonwealth concept where a grant issued in one country is taken to another country and sealed again with that country's seal. That is how the name reseal comes in. So say somebody dies in England, a gentleman dies, and men, this is just not deliberate, it's just habit, but I find the men normally die quicker than the women. That's just my experience. But say a gentleman, that's why I've always been saying a gentleman dies, not a woman dies. But say a gentleman dies in England and leaves property in England and in the Turks and Caicos Islands. His attorneys at law, the estate's attorneys at law get the grant of probate in England. But you need to deal with the property in the Turks and Caicos Islands, and normally you can't just send the grant from England there. You normally get that resealed, all right? And that's an example. I mean, I know the Turks is still a British overseas territory, so there's a little bit more latitude, but from a strict conceptual perspective, you have to get the grant resealed. So generally what you do, you apply, you still go your route and you file all these documents. In Jamaica, it's simpler. You just need to do just a couple documents and you get a certified copy of the grant with the will attached to it. So that is why it's called certified grant and copy will. And once you get that in your local jurisdiction, using the Turks in my example, you can then apply to have the grant resealed. The beautiful thing about that is you don't have to do a new grant and you don't have to provide proof of death at all, because the issuance of the grant presupposes or presumes that the person died. So the number of documents you have to do, they are reduced even more. So that is resealing, and then you normally advertise. In Jamaica, they have simplified the process by creating a special application document, and it makes life much easier for practitioners here. All right, so those are the four main areas I wanted to touch. I'm going to make some recommendations now, and then I'll open up the floor for your questions, and your answers hopefully will follow. But before we do that, there are a number of other applications which I gather will happen from time to time. One of the practitioners in your jurisdiction was speaking to me about the bonus non grants. For those who might not know, the bonus non would come from the old Latin, the bonus non administratis. It's a second or subsequent grant whereby, say for example, an executor dies without completing the administration of the estate, somebody else has to finish it. And that second grantee gets what we call the bonus non-grant. And I pause again, bear with me. I'm treating you as students, I know, but you are still bright people, not making any assumptions. There are four things you do to complete an estate generally. And I was saying this to some practitioners the other day, and they weren't even looking at it as simplistically as this, but it is that way. The first thing you have to do, you gather the assets and the liabilities. So the assets on the one hand, liabilities on the other, and you know what is your net estate. With that information, you then now file the documents to apply for the relevant grant. Having got the relevant grant, number 3, you discharge your liabilities. And number 4, you distribute the estate. The gifts under the will, last thing should be handed out. So in the example I gave earlier, Mr. Ewing, getting all these fancy shares, at the end of the day, the value of those shares might abate. So when the will was made, they might be worth 5 million, but by the time the testator dies and the estate is probated, they're now worth $500,000. Sometimes they're worth nothing. Sometimes they're just extinguished. So it is important for you to always bear at the back of your mind those 4 general things to wind up an estate. And you should never really distribute until you have cleared all the liabilities. So I know it's a mouthful, but I wanted to show in second or subsequent grants, and the bonus non is one. I've had occasion to do what is also called double probate, where a second probate is granted to a second executor. It is very rare, but it happens. And a very, very common set of grants which occur are called limited grants. So for example, and this is one of the most common of the limited grants, you just can't find the original will, but it was not revoked. It might have been damaged in Irma. It might have been damaged in some storm. It might have been destroyed by accident, which sometimes happens. But you have a proper duplicate or a proper photocopy with the signatures and so on, you have to apply for leave to swear or to prove the copy of the will. That's a limited grant. And the grant of probate is worded a specific way. In fact, your lead affidavit, or in Jamaica, the oath, has to refer to a special or court order, which you have to get giving you leave to swear the photocopy or to put it forward for probate. But I've not dealt with that in this meeting. I'll come to it. So before we go to our Q&A, and we're trespassing on that time now, I have covered all of these areas. The following are some distinct recommendations I'll make to you. I suggest that you need to overhaul your probate LA, your estate application mechanism to make it much simpler. And the Jamaican example is a great example, if I might say so myself. All right. I think you should abolish the petitions. I think you should change how the applications are made. I gather that the registrar will issue the directive for the gazetting to be done. In Jamaica, the practitioners have the responsibility of getting the thing advertised. And that is why we can, at our own time and leisure, very quickly send it to a daily newspaper, get it published, swear an affidavit, send it to the registrar with proof of the what we call the tear sheets, proof of the newspaper extracts to show that we have complied with the advertising requirements. I think you should have a proper system of marking of the wills put in place. It's not giving you more work. It is safer for the beneficiaries. It's safer for the estate. And it's a good thing for the application process generally. All right. I think you should avoid using, when I said simpler, reduce the number of documents you use as well. That is important. In section 2 of the Probate and Administration Ordinance, you have a provision which treats with intermeddling. Intermeddling is normally when someone who doesn't have the proper authority decides to do things in relation to an estate. So a deceased person dies and he was a farmer. You start to round up his goats or his cows and all of that. You are intermeddling. I think you should rework and review that particular provision as it currently stands. There is a concept in law called the executor's year, so that 1 year from the date of death of the executor, you're supposed to wind up the estate. The 4 things I mentioned earlier: ascertain the net estate, apply for the grant, pay the expenses, and distribute. Those 4 things normally should be done within what is called the executor's year. I think you need to enact some laws, if not laws, certainly public procedural requirements treating with the executor's year. Another recommendation I'll make to you is in relation to common law unions. Jamaica, when I was actually at the law school in 1988, Jamaica amended its Intestate Estates and Property Charges Act, which is a statute which deals with distribution of property or the devolution of property on the passing of someone intestate. And we created a common law individual called a surviving spouse. Based on the historic rules, you had to be married to inherit, generally speaking. And that's why the term bastard came about. A lot of people don't know it. A bastard is really actually a bird, but that's another story. So I suggest you look closely at creating a new type of surviving spouse to respect the fact that there are many common law unions and many children who are the product of those unions, where you might not have those persons benefiting because they might not have been married to a deceased person. That needs to be structured in a certain way. In Jamaica, you have to prove that you had been in a relationship continuously for 5 years and so on and so forth. And of course, the individual must be single. So even if you're married and separated from your spouse for 10, 15 years, technically you are not single. And that has happened in a lot of estate matters. You must create a proper structure with an administrator general or a public trustee who can help with all of this. And there is I don't think Turks and Caicos Island has it, because I don't remember seeing it, but I think for the purpose of estate applications, you need to create provision dealing with what we call a child en ventre sa mère, a child of the womb. In other words, when the person died, If the husband dies, who normally would be the person in this case for sure, and leaves a widow, but the husband dies intestate, but the widow was pregnant at the time, could that child qualify as a child to benefit on intestacy and someone whom has to be consulted in any way, shape, or form at the appropriate time before the grant can be issued? Because quite often you have to get the consent, which is another document you file in Turks and Caicos in various applications. You have to get a consent of a brother or a sister to apply. In Jamaica, we abolished that. So the recommendation is that you don't necessarily have to get consent, but you can give notice to the other persons. I mean, it's better to get the consent if you can, but if people refuse to consent, you can give them a notice of your intention to apply, and within 14 days, for example, you apply. There are other things we could go through, but I think in the interest of time, I will stop now and give you approximately 10 minutes to ask any questions. I know I've said a mouthful in a relatively short time, but ladies and gentlemen, I think I will pause here and thank you for your attention. Thank you for listening, and I give the floor over to you now. I don't know, Mr. Antonio is there, or Emmanuel marshalling the proceedings, or who is chairing the proceedings.
Good afternoon, Mr. Wilkinson Casey. I am certainly still here, and I thank you very much for that presentation.
Thank you, sir.
For the very informative and thorough recommendations.
Thank you, sir. You're more than welcome.
Before I hand over to the open floor for questions, I would like to read one that came in the chat, and it's from Mr. Hugh, who asks, what additional steps do you recommend for vulnerable clients whose memory is suspect early stage dementia or other impediment, or who appear to be under undue influence from proposed beneficiaries?
That's a very, very interesting question, because we have had a number of cases like that here. In fact, in Jamaica, they tend, in some instances, to there's a really laborious mechanism where with an individual who is suspect, I said before the person dies, you have to appoint what they call a committee. They are relaxing that now and making it simpler, where you probably can just have a family member appointed as a kind of special trustee. But listen, if we're dealing with estates, so if an individual, let's look at it in two stages. If that person is still alive, because estate planning covers not just estates after the person dies, but what you do while the person is alive. So if that, and that's something which is a whole nother lecture, which I could do, but if that person is still alive and is vulnerable, then quite often the person who has his or her best interest at heart might need to get guidance from the court, get directions. A lot of times in Jamaica, you file an application is made by a fixed date claim form to get certain directions as to how that person's life is to be handled, who is to have conduct or care of that child or individual, because quite often, if the person is very wealthy and now becoming senile or having dementia and so on, you find the beneficiaries coming flocking like flies to honey because they want to be near and to show their faces. So if you are the eldest son and you think you have the best interest at heart, it might serve your purposes to file an application seeking to have yourself appointed as the direct trustee for that person. If the individual is dead and it is suspected that the person had dementia when the person, and I'm taking it to another level, has died, then it might call into question the validity or the testamentary capacity of that individual when the will was made, and you might have to seek what we call an order in solemn form from the court to verify that the will itself was actually made when the person had what we call the animus testandi, or testamentary capacity, along the lines of cases like Banks and Goodfellow, Ray Bund, and so on and so forth. Okay, Watton Singh and Amerchan, you have a whole line of cases dealing with it. I hope I have addressed the question.
Thank you very much. We have a second question from Mr. William Belliard. In the absence of the executor's year provisions as you have in Jamaica, what steps would you take where in excess of 2 years have passed and the executor has not distributed the estate?
That's a very, very good question. And in fact, that situation occurs quite commonly. I'm dealing with an estate now, which is a very huge estate, probably the biggest estate in Jamaica's history. And I'm not going to call the names of the individual, although some might speculate as to it. But more than 2 years have passed, certainly since the death of that individual, and the executors have come under tremendous pressure. So if the executor's year has passed and you have no specific provision treating with the executor's year, what the law says is that the estate must be wound up within a reasonable time. What is a reasonable time will depend on the circumstances of the particular case. An oft-used expression, but a hallowed and very useful one that judges and lawyers will use often. So it might be that 3 years after death is not unreasonable, depending on the circumstances of that particular estate. It might be that 18 months is far too long because it's a small estate and it's in good order. The testator kept himself well organized, was a very meticulous person, and therefore the estate could be wound up without much ado. So it depends on the circumstances. But my suggestion would be, if the time is passing, there are provisions in various places where you can cite the executors to accept or refuse probate, meaning you force them to put up or shut up. You have to get the grant now, and you can go to the court to get that done. You can get a citation done. If there is no provision for citation proceedings in your jurisdiction, you can actually bring an application by a fixed date claim form to force them for directions, setting out what is the issue, why it's taking so long, and compel the executors to come before the court to give an explanation to the delay or leachees, as we call them. So that is how I would suggest you approach it.
Thank you very much. And now the floor is open for any questions.
Any further questions? Yeah. I'm seeing a question which says, how do you deal with a situation where an attesting witness have died, but no death certificate can be produced to prove death because the witness went missing and nobody was ever found? All right. So, and when you said no death, I'm assuming this relates directly to the attesting witness. So if an attesting witness has died, but based on your personal situation, you require an affidavit by an attesting witness, an affidavit of due execution, whatever you want to call it, because there might be problems with the will sometimes, sometimes, as in some cases, the testator's signature might not be in the testimonium clause or at the end or wherever. Sometimes you have wills where the testator's signature is actually cut at the top of the first page, whereas the will is 2 or 3 pages. And you see the signature at the very top, and you might have the witness's signature on the second of the 3 pages. The positions of those signatures requires an explanation. When you see the position like that, that requires an explanation. So if the witness is not around, you have a major problem. If the witness is dead, it means you can't get that witness to sign anyway. What is the next best step? Separate and apart from proving the death, because even if you cannot prove the death, that witness is going to be absent anyway, and you need an affidavit. So the witness doesn't have to be dead. The witness could just be missing. The witness could have migrated or whatever. What the courts tend to want, they want to find out if there's anyone else who might have been present who could swear to the attestation who was not one of the official witnesses. That is the next best thing. If you had nobody present, if only the 2 witnesses were present, and both are dead or missing for whatever reason, you can have someone swear an affidavit as to handwriting. Because what you want to prove is that the will was properly executed. And you can say, this signature I see at the foot of the will, that was my father's signature, and that was my mother's signature, and so on. So you could have an affidavit of handwriting. If you can't have any of that done, the final resort is to put the matter before the court to have the will proven in solemn form, where a judge can actually grant the probate, but this is no longer non-contentious probate. It's going to be in solemn form, where the beneficiaries, who are all what we call sui juris, over the age of 18 or so on, if any suffers from disability, being under 18 or mental incapacity, you might have to get their guardians or next of kin served with the papers. But what you will do you would put before the court the persons who would tend to be prejudiced by the will being valid. Because sometimes you have people who benefit a lot on an intestacy and they want the will to be struck down. You bring everybody who has an interest and then ask the court for directions. And if you want the will upheld as an executor or beneficiary, you can ask that the will be proven in solemn form. I know it's a little long, but I wanted to cover a couple other things as well.
Thank you very much, Mr. Wilkinson. Casey?
Yes, sir.
So we just open the floor for one final question. If anyone would like to say something or add a comment.
Mm-hmm. Mm-hmm.
If not, that is the end of our time. So I'd like to move directly into the formal vote of thanks.
Sure.
So as I move into the formal vote of thanks, I see one comment in the chat which just says thank you to Mr. Wilkinson, King's Counsel. So on behalf of the Judicial Education Institute, I'd like to thank Mr. Wilkinson KC for joining us this afternoon under the inclement weather in Jamaica and the weather that we are bracing for here ourselves. So we hope that we have it fairly easy here.
Yes.
I know it would have been difficult to come here today, but as you hinted to in your presentation, where there's a will, there is a way. So we're glad that you've joined us here. And on behalf of the chairperson of the JAI, the Judicial Education Institute, and all our attendees, I thank you very much.
Well, you're more than welcome. I see you have suggested an answer to my question. I always tease my students and tell them that where there's a will, there's a beneficiary. But that's not always the case, because you have strange cases where you do have a will, but no one benefits. I've seen that case as well. But it's my pleasure to be here. I don't know if you can hear it, but it's thundering outside right now, and it's very gray outside. I'm glad the internet has held up. And I want to thank you for taking time out of your busy schedules. I miss the Turks and Caicos Islands. I've not been there since the end of September. Hopefully I'll be back sooner than later. But thank you again for making it. I hope to have a couple of follow-up seminars or presentations based on questions which have come to me. And you take care until such time. And please don't hesitate to drop me a line. Mr. Emmanuel can give you my contact information if you have any questions you would like addressed. But again, thank you and have a great weekend.
Have a great weekend, Mr. Wilkinson, and have a great weekend, everyone. Thank you very much for joining us.
All the very best to all of you. Miss Akira Misick, particularly. Hope to see you one of these days. And all the very best to you. Thank you.
Thank you.
Bye-bye.